A group of former officers are trying to advance their legal challenge to the Boston Police Department's drug testing. They argue the use of hair samples has a racially disparate effect, with false positives more likely among African Americans. To bring us up to date on the challenge are one of the plaintiffs, that is an organizational plaintiff, the president of the Mass Association of Minority Law Enforcement Officers, or MAMLEO, Larry Ellison, and an attorney with the Lawyers Committee for Civil Rights and Economic Justice, Laura Maslow-Armand. Thank you both very much for being with us.
Thank you for having us.
I want to start with Larry Ellison, the disparities, the racial disparities that got this case going. How extreme were they?
Well, let me first say this, Chris, that MAMLEO, we're not against drug testing. What we're looking for is a fair test, a test that is not biased. And the answer to your question, this goes back quite some time. It's been over 12 years that this process has been ongoing. And it's a test that scientifically has proven that it has a disparity against people of color, African Americans particularly, that just because of the mere makeup of our genetics, that if there was a trace of something, it could be longer, or it may not even be that there is drugs in your system, but this test will say that it is.
And how extreme are the numbers, as far as you can tell?
I think Laura's going to speak to that a little bit, but they're very extreme. And when you think about the number of officers, of black African-American officers who have tested positive, and the number who have said that they did not test, but the test says they do, the city has said that this is 100%. And we've had cases in which they've had to walk it back because it wasn't the case, and these people still have their jobs because there's been some flaws with this. So you're asking people to put their livelihood on the line or to admit to being a substance abuser when they're not.
Laura Maslow-Armand, one thing you've succeeded in doing with the plaintiff so far is have a federal judge say that there really might be something wrong with this test.
The federal judge has said that the statistics show that there's a disparate impact. So that is already settled. The First Circuit said that on appeal. The statistics show that there is let's say 5 times more likely to test positive and that is so extreme a statistical difference that it cannot be due to chance. And that then brings the case to the next 2 prongs of a disparate impact challenge. The city will have to show that the test, even though it has a disparate impact, meets a business necessity, and the plaintiffs have to show that they have a less discriminatory alternative to that test. And that's what is before the First Circuit Court of Appeals and will be heard on September 8th.
What about the science around it? Is there any reason why an African American might be more likely to test with a false positive?
There is, first of all, large consensus among independent research toxicologists that the test is not 100% accurate because of the differences in hair growth, the differences in the collection time or the weight of the sample, the timing of the analysis. The hair is liquefied, for example. And so you're talking about something that is probabilistic. And so starting from that, you have, according to, I would say, one of our experts, who's David Kidwell at the United States the Naval Research Laboratory in Bethesda, who, as early as 2003 in this litigation, told the city and the police department that the nature of African American hair being dry, very, very tightly curled, and tendency to be brittle, allowed external contamination, which is more likely for police officers who are working with people who are using drugs, and also the neighborhood in which they live. So the external contamination that's on the hair of an African American is more likely to penetrate into the heart, into the hair shaft, and bind to the melanin. One of the toxicologists in the 90s, 1990, named Joseph, said that there was a 50-fold greater binding of African American hair to the melanin, the cocaine to the melanin in African American hair, as to blonde Caucasian hair. So there was a huge difference in not only the binding quality, but the rapidity of the intake of the cocaine into that hair. and it can't be washed out once it's bound to the melanin. So that's going to skewer the results of the test. I think that most toxicologists, whether they run a hair testing lab or whether they're independent, will say there was cocaine in the hair, but we cannot tell for certainty what is the source of that cocaine.
We're talking with Laura Maslow-Armand from Lawyers Committee for Civil Rights and Economic Justice and Larry Ellison from MAMLEO. Larry, what about the officers who tested positive and maybe lost their jobs or maybe might have been forced into admitting they were using drugs?
Well, and that's one of the issues, Chris. You know, one of the officers, Ronnie Jones, specifically, who I knew when I was a young officer, when I was a police cadet, going back over 31 years. Now, this is a gentleman who I have the utmost respect for. I have never seen this gentleman in any way incapacitated in any way. I mean, he is a church-going man, family man. Matter of fact, he is currently a deacon in his church. He has gone on with his life past the police department, but what he had to go through, having had worked his whole career in an exemplary fashion, then to be asked to say, yes, I am a substance abuser, and admit that just to take the 45 days to try to move on with his life, when some people have opted that because of financially, they couldn't afford to go through the suspension or the termination from this result. So in some ways, people like Ronnie are standing up and saying, I can't do this. I cannot admit, even though I haven't done it, and this will get me past this, I will not do that. I will fight this. And he's doing that.
Laura, what about alternatives to this? Is there something else that works better?
Chris, just to add something to to Larry's very good depiction of Ronnie, he failed that test by 1/1000th of a gram. That destroyed his livelihood, his reputation. And you're dealing with such minute quantities of cocaine that, to answer your question, we're not saying even keep the hair test if you want. It's actually being used today in a somewhat different protocol. As of 2007, the department modified the protocol and allowed what we call split samples. On the same day, you would take 3 samples of hair, rather than testing confirmatory with a new sample. So you have 3 samples of hair the same day. You would look to see what the discrepancy would be in the first 2 samples, and then the officer could pay at his own expense or her own expense to have a Quest test the 3rd sample. So very few people are failing today. So that's already a different model. But Dr. Kidwell, as early as 2003, argued that you could use the hair test, but accompany it with random urinalysis. You could do it several times a year. And that, in fact, actually, an officer who fails the test and who signs the settlement agreement takes a 45-day suspension and then is tested by urine. He's back on the force with his gun, and they're relying on a random urinalysis. So we're saying just combine that. Use the hair test as perhaps something that maybe would be presumption, but don't fire an officer. Don't terminate an officer just on that. The test can't stand it. And it doesn't have enough reliability. And the Massachusetts Civil Service Commission adjudicated the hair test with experts on both sides. And in 2013, February 28, 2013, the Massachusetts Civil Service Commission unanimously ruled that the hair test is too unreliable to be used to fire a tenured officer. And the Superior Court affirmed that decision and reinstated 5 of the plaintiffs with back pay from the time of termination. So there is an alternative. The test is not sufficiently reliable to be used alone.
Yeah. Larry, was there ever any point along the way when the command staff and the police department might have been willing to sort of sit down and work out an alternative to this?
Well, that's one of the issues, Chris, is that because MAMLEO is not a union, we're never brought into the conversation, the discussion. And I think it would be helpful if that were the case. You know, we have over 400 members who are Boston police officers, and the majority of them are members of my organization. and our organization speaks on their behalf. And when these issues come up, a lot of times it's not the unions that are representing them in these discriminatory cases. It's MAMLEO that's doing so. So no, there hasn't been a willingness on this department to give at all when it comes to these type of issues.
By the way things stand now, what do you think this says to people of color who think about being a police officer?
Well, I think what it says, if you take a look quickly about the body cameras, right, and that they were not able to get one person to volunteer, and people ask me numerous times, why would not MAMLEO's members step up? But when we feel like we're mistreated when things happen, why would I want my members to take a chance on having a video viewed differently if they were doing it, or if it was an officer that was not of color on the video? So this drug testing is very similar, is that we don't feel like if the results somehow are not correct, that we're going to be given the benefit of the doubt.
Laura, this has been a long case, so you have something coming up very soon. What's going to happen?
On September 8th, before the First Circuit Court of Appeals, they will look at those other two prongs, the business necessity and the less discriminatory alternatives. The effort is to reverse summary judgment on District Court Judge Woodlock in 2015. And it's it's hard to get a reversal of a summary judgment of a federal district court decision. But we're arguing, first of all, there was probably no need to continue this case since the Civil Service Commission, with experts on both sides, roughly the same plaintiffs and defendants, adjudicated this matter, looked at it and said it's not sufficiently reliable. And therefore, we argue there was no need to continue to litigate. Also, we feel that the summary judgment decision perhaps improperly gave the case to the defendants when there were serious factual issues in dispute. So a victory in that case before the First Circuit could remand the case back to the district court, or we could be in trial. We could have a trial of all 10 former police officers and the organizational plaintiff, and that would take a lot of time, use a lot of resources, but that is a possibility ahead of us.
Thank you both very much for being with us. Laura Maslow-Armand from the Lawyers Committee for Civil Rights and Economic Justice, and Larry Ellison from MAMLEO.